The YSL Young Thug RICO trial was a complete disaster. It began with opening statements from the prosecutor presenting PowerPoint slides they never turned over to the lawyers. Thug's lawyer then immediately requests a motion for a mistrial, which ends up getting denied. But towards the end of this video, Shannon, Stillwell's lawyer, gives the opening statements and does a decent job at showing how shaky the state's case is. Today is very chaotic. The prosecutor makes a few mistakes with PowerPoint slides, but she does a good job at painting the picture of Thug being like a big mob boss. But once again, she blindsides the defense team with information. Insane. She's done this for like a year straight, blindsiding the defense. I don't know how the judge keeps letting this go on. I mean, even on opening statements, she did it. Pretty crazy. Yeah, hit subscribe right now, like this video, comment down below. And here's the first look at Thug in his suit with his hair all done. Looking right at the camera right now, damn. He's side-eyeing the camera.
Counsels, we are at this point in time waiting for one juror that has still not been able to be located. I have asked our sheriff's team to go ahead and see if they can find her, and that's what we're waiting on at this point in time. So
apparently this juror was having car trouble this morning. Doubt it, but yeah, they were probably just late. Here they are an hour later now, right here. That's Mr. Stillwell, by the way. I'm gonna try to give you guys more context to who is who. I believe Stillwell is, you know, a known shooter in YSL, if you know what I mean. Thug's looking good though. He's looking presentable. A little bit of a belly looking right there, but you know, the jury is entering right now.
Good morning, ladies and gentlemen, jury. Oh, come on, that sounds so lame. Come on, let's try that again. Good morning, ladies and gentlemen. Good morning. Oh, much better, much better. Ladies and gentlemen, as you know, I'm Chief Judge Earl Glanville, and I'm presiding over the trial of this case.
This is D-Rod, I believe his name is. He's already convicted of murder with another defendant from a 2019 murder where they killed a 15-year-old and shot him in the head.
The lawyers attempts.
He was like 16 or 15 at the time of the murder too, but he got life in prison. This is Huey right here. He did a few armed robberies apparently, I believe, and he got arrested for them in like 2019 and 2021.
The case until all of 18 of you are present. If something unexpected happens and you absolutely cannot help
There's 6 total defendants, by the way. This is Yak Gotti right here. Here's Thug's charges right here.
County Grand Jury has indicted the defendant Jeffrey Williams for the following crimes, which I will now read to you: conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, possession of a firearm or commission of a felony, and possession of a machine gun.
No murder, technically. They're not accusing him of actually shooting anyone, but they accuse him of, you know, basically putting out hits on people and being involved in telling people what to do type thing.
Other defendants have pled not guilty to this indictment, and each of them deny every charge in it. This indictment and the defendant's pleas of not guilty present the issue that you've been selected and sworn to decide. Each of the defendants is presumed to be innocent until he is individually proven guilty. The defendants begin the trial with a presumption of innocence in their favor, and this presumption stays with them until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendants are guilty of the crimes charged. You may not convict any one of the defendants of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment.
That's a big statement right there. The burden of proof is on the state. These guys are presumed innocent. That's a big mindset that these jurors have to have.
And the burden never shifts to any one of the defendants to prove his innocence. However, the state is not required to prove the guilt of the defendants beyond all doubt. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based upon common sense and reason. If your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendants not guilty.
So they don't want certain witnesses or people in the courtroom or family members to hear the opening statements. So there's so many people in the courtroom that they have devices to listen in to a sidebar. You could say there's too many people in this case, dude. And the funny thing is they were trying to do 28 at a time. This is only 6. How the were they ever going to do 28 at one time? That was not ever possible. Here we go. Miss Love right here, one of the prosecutors, is about to start her opening statement. Let's get it.
And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. But the strength of the pack is the wolf. And
she is reciting a book right now, the Jungle Book or whatever, dude. I see the chat just freaking out saying she's reciting the Jungle Book.
Nothing that I say to you during this part of the trial, and nothing any other attorney says to you during this part of the trial is evidence. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. For 10 years and counting, the group calling itself Young Slimelight dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock Crew. In fact, is a criminal street gang. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago, but make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, that committed crimes on behalf of and in furtherance of Rock Crew itself, under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. The defendant, Jeffrey Williams, seated back there yawning right now, he was an original member of Rock Crew. And the kind of crimes that Rock Crew did consisted of smash and grab burglary, stealing ATM machines. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Criminal street gang activity, that is crimes, that were intended to further the purposes and the advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL. The members and associates of YSL, they moved like a pack. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. The evidence will show that YSL checked all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery.
I want to point out here, it's kind of obvious YSL was a gang and also a record label. That's just my personal opinion. But is she going to be able to convince 12 people? I don't know. Beyond reasonable doubt, I don't know if these 12 people will be convinced enough, especially in Atlanta. I think 9 of them are black too. That's a big thing you have to think about in this type of case in Atlanta.
Stolen firearms, so many stolen firearms, possession of a machine gun, and narcotic sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting.
Oh, wait, what? Did she just put the burden on the defense?
you will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now is
Let me object. And under Parker versus the state, that's
Why don't we take that up then?
39.
I'll note your objection. I'm sustaining the objection once you rephrase the matter. I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier? That the burden never shifts to the defendants to prove for certain innocence, they're presumed innocent.
the evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. Because of his age and his cunning, because of his right.
This
and
is
his
argument. This is not
What's your objection, Mr. Harvey?
that it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, sir.
All right.
She's kind of sloppy, I'm gonna be honest. She seems unprepared, which is kind of crazy because this is like a year and a half going on here, but whatever.
That the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when
She portraying Thug like a mob boss.
members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King Slime, as they call him.
Or I can't believe this is really happening in 2023. Who would have thought Thug's career would lead to this right now, dude? Lyrics are about to be used against him too.
Committed armed robbery. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. Did something to what Jeffrey Williams had perhaps considered a friend. They were threatened with their very life. Tell them to get that stuff back or they will be killed. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF.
Peanut got shot, Donovan Thomas. He was in his Tahoe, and then Thug put Tahoe in one of his lyrics saying they shot him up or whatever. So that's what she's probably going to point out at some point.
One of the members, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies. You'll find that as a result of this gang's activity, a young woman who had nothing to do with either YSL or any of their opposition was gunned down.
I believe it was Shannon Stillwell was in a car with someone and she got killed because they were trying to target Shannon Stillwell, I believe.
No less than 50 shootings occurred over the course of the next several months. Hundreds of bullets were fired into cars, into homes, and into people. As a result of the rift Young's Limelight had with other people.
Yeah, overt acts are a little confusing, but an overt act, they're going to say this a lot in this trial. You know, buying a mask is perfectly legal. You can go buy a mask right now. Anyone can. But if you're buying the mask to, you know, rob people or commit crimes, that's an overt act.
And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023. Of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted, where they held long-going guns by the door.
Your Honor.
You have an objection?
Yes, sir.
Basis?
A motion.
Oh shit, he said a motion. Uh-oh. He's got to do a motion for mistrial.
All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to the Honorable Court's attention? 1. And 2, how do we just violate?
Whoa. They had that he was representing Lil Rod in an appeal. I don't think he is.
Court order. So, yes, I have a serious motion for mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use as it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal. I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence the state expects will show.
I never said this.
So what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this Honorable Court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
You brought him up to this Honorable Court, outside the presence of everybody. We're an opening statement. I am lied to. I am saying that I am lied to. I don't know if anyone else got that exhibit. I did not get that exhibit. And now it goes against the court's order. We are bound. Can we bound to follow Honorable Court's order?
He's pissed and he has a right to be. There's already been motions granted regarding them turning over anything and everything to the defense, and of course they fucking fail. This prosecution is so sloppy, dude. How were they ever expecting to do 27 people or whatever at the same time? There's only 6 and they're struggling.
I'm going to join in the objection on behalf of Mr. Steele.
Let me see the...
As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that. I ruled upon that last week. I did.
Ryan, along with YSL member Damon Blaylock, he was 190, put a bullet in the back of the head of Jamari, aggravated assault Rodney by shooting at him with a gun, convicted case on appeal represented by Brian Steele. That's crazy that I put that on there when he doesn't even represent him. That's a huge mistake.
Represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what was it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time.
He's going to tell him to disregard it. That's what judges do. I find that so funny. Like, disregard what you just saw. Don't act like you didn't see it, basically, but they already fucking saw it, but whatever.
What do you mean by what displays are you talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw
The wolf.
The indictment. You ordered I gave all my displays. I gave everything to the state. I got from the state.
Are you talking about using for opening statement, sir?
Of course.
Okay.
Should have been done.
Why isn't he yelling at this prosecutor? Because she fucked up big time.
I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name, on
I got
here.
that, but he's talking about, is there anything else you're going to use in opening you haven't shown to defense counsel? He's telling us, well, I said that. I told you to do that a week ago.
Your Honor,
because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Hijacked me at the bench. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. This is stuff we can take care of before our jury comes in. And that makes you all lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. Have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
Can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, can you find out if our jurors are ready?
Your Honor, Jay Abt on behalf of Mr. Kendrick, can we have 5 or 10 minutes to review whatever Ms. Love is going to send up?
An absolute disaster.
All right, if we concluded our sharing exercise, I told you all to go ahead and talk with each other when we broke.
I did share it, Your Honor.
All right.
Regarding the court's
So she apparently shared everything now.
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but
This is Lil Rod's lawyer right here, one of his lawyers, and they're trying to put in that little detail of Lil Rod posting something on Instagram after the murders in the opening statements. She's saying the court already ruled that they can't do that.
Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose. It's what they expect the evidence to show. So I'm disappointed as the court. You all we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up. The jury's sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so.
They put it in their motion as intrinsic evidence, though, so they shouldn't have put it in their motion if they were going to.
Yes, ma'am, I would probably agree with you, but did I ever rule on that issue?
You said that you would do it later as it came
Okay,
up.
well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. Do you have any other basis for the ruling? I mean, for my ruling now?
So he's mad at her for not pointing it out before.
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks, and my client has nothing to do with that.
that was another area.
But I didn't get that
Ms. Love says
clarification
Ms.
earlier.
Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
That was a mistake. Wait, hold on. This is fucking crazy. They had one of the defendants named down for a murder he had nothing to do with, and they were trying to show in opening statements. Prosecutor just admitted that she did it wrong. This is an absolute clown show.
PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share it with the state and for the state.
Oh my god, this prosecutor, dude. Why would they not turn over slides when the court already ordered they turn over everything? I feel like I'm getting pissed over here. I'm a little ginger kid watching it. I'm so annoyed right now.
To share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. The court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument. No one's suggesting that she had to turn over the text of her opening argument, but if she's going to show a PowerPoint to the jury, that is what the court instructed us to share, visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, and she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying. But if that's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared prior to opening. If there's, and no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of our opening that violates this court's order that we were supposed to share exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening.
On behalf of Mr. Stillwell, slide number 47 suggests that Mr. Stillwell is still committing crimes on behalf of the gang, even after being indicted on these charges. Get a ruling on its admissibility yet, and I would ask that that just be taken out of the presentation and no mention be made.
Yes, Mr. Steele.
Just every lawyer standing up complaining about the slides that were never presented to them whatsoever when the court ordered it.
Ms. Love, I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. This is what's caused this delay, because at this point, like I told you, there's no secrets in the trial of this case. But this just highlights the concerns the court had. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30.
Opening statements interrupted because she included slides she shouldn't have included. that had a few errors on them, saying that someone was part of a murder they weren't part of. Think about how crazy that is.
Mr. Steele?
Yes, Your Honor, I was unaware that there were changes. I apologize. No one told me that. I didn't get an email to that or text.
I told you all to do that during lunch. That was my last conversation with you all before I went ahead and broke for lunch.
That's what I've been doing. I'm waiting.
You know, you all don't listen to the court, and it's going to get you all in a lot of hot water.
Wait. Thug's lawyer didn't know they were supposed to do some changes to the slides? How did he not hear that?
You need to listen to me when I tell you something, and don't rely upon your own understanding. If you have clarification, ask me at that point in time. I'm more than happy to do that for you. But that's not what I told you all to do during the break. You didn't follow my instructions, Mr. Steele. I mean, that's what I asked you all to do. I asked you all to share each. We're already behind to begin with. So, any further objections?
Yes, Your Honor, I didn't know that they were changing.
Yes, Ms. D. Williams.
And on slide 10 and 13, they misquoted the Instagram post.
Again, they misquoted it?
Yes, they did. It says, I bet YSL make the news tonight. That's not what the Instagram post says.
Your Honor, we actually copied the Instagram post into slides 10 and 13.
And it does not say tonight.
I'm sorry, okay.
Oh, she added the word tonight to it. She said she copy and pasted, then said, oh my God, she added the word tonight. What is this prosecutor doing?
Anything further?
Hi, on behalf of, I think, everyone in this back row, we're seeking clarification. Is the state saying that the same link that they sent earlier before the changes will now show an updated version?
In fact, it does. It has on every other person's computer who has this.
I understand what the state's saying now. The confusion is no one on the defense team we were waiting on a new email with a new version of the PowerPoint.
That's not what I told you all to do. I was pretty clear. I said, y'all, over lunch, just take a look at the state's PowerPoint, make sure you have no further objections. I didn't tell you to email it to you. I just told you to look at it. I don't care how you did it. That would be the thing I would probably have gone through and said, hey, let me see slide 1, 2, 3, 4, 5, 6, 7, 8, 9, whatever else.
Okay. Yeah, we were waiting. We had voiced some concerns already, and we were waiting on a new version.
Oh my God, what a bad miscommunication error. They thought they were waiting on a new version of the PowerPoint. They didn't know the link was going to auto-update in the PowerPoint file. Oh man, what a disaster. We're 4.5 hours into this trial, and the prosecutor has done like 10 to 15 minutes of an opening statement. Like, that's how much of a disaster this has been.
On that old link, I think people were waiting on a new version of the PowerPoint.
Okay, here's what I'm going to do. I'm excluding the PowerPoints. Y'all just going to have to make this thing up the whole way. You have to just make an opening statement. No PowerPoint.
Yes, that's what you should have did that fucking 2 hours ago, Judge. I mean, holy fuck, I know he's trying to be fair with the prosecutor, but like, she brought a fucking PowerPoint slide in that she never gave over.
You all did not do, hold on, I'm starting. You didn't do what I told you to do, and that was to exchange PowerPoints. We have wasted almost 2 hours trying to get this stuff done. My orders to you are not aspirational. They're given for a reason. And when you don't follow them, then I have a way to remedy that. So the remedy is nobody uses no PowerPoints, okay?
We have provided our opening statement to the state of Georgia as well as to every other person on the defense side. We have received from the state of Georgia an updated, came to my email from the state of Georgia with the changes as it relates to Mr. Hume. If I am not able to use my opening statements, I prepared my case with my opening statement. I have not committed every single slide to memory, Judge.
No, all the lawyers are freaking out because they didn't memorize their opening statements. Obviously, because it's a lot, and they're all saying they turned it over like a week or two ago, but the state didn't do that. So the state fucked this, pretty much, is what you're saying right here.
I did everything the court demanded.
The court's directive was you were supposed to turn this over way beforehand, because then we could have corrected these issues and not spent 2 hours in doing this. I'm deeply disappointed in, because this is exactly what I told you all was going to happen, was that we were going to end up dealing with a lot of objections.
This is a reoccurring issue with this fucking prosecutor. I know there's probably a lot of new viewers watching this. My fucking glasses are fogged up, dude. But this prosecutor has not been giving over information to the defense this whole trial, whether it's discovery being delayed or witness list, because the witness list is over 700. Yeah, you heard me correctly, 700 witnesses. They wouldn't disclose who they were actually going to call up. The judge was basically begging who they were actually going to call up of the 700. So this is a reoccurring issue with this prosecutor. She's getting sloppy right now, boys. So the prosecutor should be punished right now, to be honest, not the defense.
Objections, and I don't mind dealing with the objections, but I gotta have time to do so. So that's why I told you I had to start having this discussion with you about a week, almost 2 weeks ago. Mr. Steele brought that up, saying, hey, go ahead and turn over your PowerPoints so that we can go ahead and, if the court mentioned, have as smooth as an opening statement as we possibly could.
So they are now bringing the jurors back in. The PowerPoint slides are allowed back in now because everyone pretty much begged for them to be back in, including the defense. So here we go.
I need to kind of just advise you of just something that was said to you earlier, okay? So with your patience, all right, I believe the state counsel earlier referred to some representation of the parties, and I just want to remind you of 2 things. Remember that opening statements are not evidence, and that what the attorneys say is not evidence.
Rodelius Ryan is one of those people whose youth and life was swallowed up in the crater created by YSL. The evidence is going to show that in 2019, Rodelius Ryan was 15 years old, used female acquaintances to lure Jamari Holmes to a particular address here in Fulton County. The female acquaintance lured Jamari Holmes to that address, telling Jamari that he would get sex, and we...
I've heard of this situation where girls help set up someone to be robbed or killed or something, and that's just so evil.
The female gets out of the car, and the defendant, Rodelius Ryan, and his accomplice, Damone Blaylock, also a YSL member and associate, they then came out to the car. The evidence will show that Rodelius Ryan and Damone Blaylock then fired those guns into the car. Jamari Holmes, not even 20 years old, and hit him in the back of the head with a bullet that took his life. Jamari Holmes is another one of those young lives, the evidence will show, that was swallowed up by the crater that YSL created. Rodelius Ryan posts on his Instagram account, I bet YSL makes the news. The evidence will show that in posting about YSL as it related to his flagrant, overt act of extreme violence, Rodelius Ryan was agreeing to and attempting to participate in YSL through this illegal activity.
Oh, that post after does fuck him. Him involving YSL in a post after committing that.
He said slime over sluts. Slime over sluts while posting a YSL gang hand sign.
I'm keeping my screen full because they're showing an autopsy in the corner of the kid that got shot in the back of the head right now.
That most recently in May of 2022, where some of these defendants were found at the home of Jeffrey Williams, their leader. It wasn't just stolen handguns that YSL dealt with. It was machine guns. At the home of Jeffrey Williams, in addition to the pharmacy full of drugs, that there is a gun with a switch.
Yeah, he had some switches. He had drugs and switches in his house. Goddamn arsenal and a pharmacy up in there.
That allows, with one trigger pull, 10 times more bullets to come out at a time than if you just had a regular gun. There will be no evidence to show any need for that in legitimate, ordinary, record deal making business. That the existence of those dangerous weapons like the machine gun, the stolen firearm, those things are all evidence of these defendants' conspiracy. Those things are all evidence of the existence of the enterprise known as YSL, whose goal it is to maintain and retain dominance, control, and ill-gotten gains. What Marquavius Huey did was kind of slimy, the evidence will show. He told Mr. Holloman,
He just said what Marquavius Huey did was kind of slimy.
Mr. Williams to see, hey, I got this stolen item. You want first dibs on it?
If they got some text messages and shit like that, oof, oof, oof.
The evidence will show that at least one person took a step towards furthering that goal. So when you get the indictment, after however long it takes us to get there, and you're looking at 191 acts and thinking, state, really?
I sustain the objection.
Thank you, Judge. I'm moving on.
Move on. That's our.
Yeah, why?
The evidence is going to show that these steps that they took are akin to you just going out to get some toilet paper to further a conspiracy to go TP your house. Doesn't have to be a crime, it's just an act, an action. That the defendant, Jeffrey Williams, rented a car. Notwithstanding that Jeffrey Williams had his own cars, but he rented a car, which happened to be a silver Infiniti sedan, that other YSL members, among them Demonte Kendrick and Shannon Stillwell, used when they openly and notoriously gunned down Donovan Thomas. The evidence will show that after that horrific act, I expect yet another YSL associate will come in here and tell you that Jeffrey Williams paid them money, gave them money to go to Miami and lay low.
That's just a terrible look for Thug. Apparently helped rent a car and then gave them funds to go lay low in another state. Like, Jesus, bro. What terrible decision making.
Later that month, on January the 26th of 2015, Davikion Garlington, who isn't before you for your consideration today, but who is in fact a YSL associate and co-conspirator of these defendants, a video of the defendant, Jeffrey Williams, looking into the camera and saying these words. So, I had to lie to their mama, lie to their kids, lie to their brothers and sisters, and then get right into the courtroom and tell the God's honest truth. Don't get it. Y'all need to get fucking killed, bro. That's from me and YSL. The defendant's words tell you that there is an enterprise. The defendant's words establish his willingness and agreement to participate in this enterprise. He didn't say that's for me. He said that's for me and YSL. And as the evidence will show, that's akin to him saying that's for me and my pack. We didn't chase any lyrics to solve any murders. Law enforcement in Fulton County chased the murders and found the lyrics. They're investigating, they're finding out who committed it, and after doing all of that, they happen upon lyrics. Lyrics that have an uncanny similarity to very true and very real and quite specific events, as the evidence will show. Take this shit to motherfucking trial. I rap my life for real. For slimes, you know I kill. I'm undefeated, like feds came and snatched me. I don't know, no point in asking. I was on what? Believe it. Stuck like a magnet. Bitch ass nigga. I shoot at your man, you need to stand down. I up my stamina, take it to trial. Get an appeal, take it to trial. Yeah, you gon' whack 'em. Pay for that casket, that's just if we whack 'em. My young niggas pulling up. Bentleys, Aston Martins, Rares and Teslas, strapped with an FN. You're gonna hear a lot about FNs. Watch me whack that bitch. Pop 'em like assist. Glock with the assist. The gun at the home of Jeffrey Williams on May of 2022 that had been modified with that switch. It was a lie. Jeffrey Williams' words and actions further reflect his agreement to participate in this organization through this criminal activity.
I'll be honest, she's kind of snapping right now, making him look like a big, bad boss. The chat says otherwise, saying she's just lying. She's definitely doing a good job painting the picture.
Through that music, through that blessing, the evidence will show that Jeffrey Williams led the group of people that wreaked utter havoc on Fulton County. Jeffrey Williams' words and actions, as the evidence will show to the members of his gang, you'll hear in a conversation he has with them, y'all ain't beat him up or shot him yet, y'all ain't getting soft. The evidence will show that there's no place or need for that kind of edict or statement when all you're doing is making music.
Nickname Peanut, I believe, or Nut, Big Nut, some shit like that. I think he was one of the higher up guys in the If gang.
You'll see evidence that Donovan Thomas was literally in the middle of lapping it up with his friends when a car drives by and opens fire on him and whoever else might have been in close proximity to him. Wayne Carter, otherwise known as Lil Wayne.
Oh shit, they're bringing up the Lil Wayne shooting.
So what they did was they waited until Lil Wayne leaves. Gets in his tour bus and is attempting to leave. They get up beside the tour bus and they unload bullets into the man's tour bus, except to show their dominance. There will be no evidence that Lil Wayne threatened either of them that night. But that act on the part of Jimmy Winfrey and the defendants before you today, that act was intended to show their solidarity.
100 rounds in a Tahoe, N-word lighting up your taco. This shit, slime shit, killing 12 shit.
By YSL members, the lyrics they chose to speak, they bore a very eerie significance. That Donovan Thomas's Tahoe had bullet defects all along the back of it when they sprayed.
They're talking about Chris Eppinger right here. His name was Briss or whatever. That's his nickname. He shot a cop in the head and then like 5 or 6 times in the body, and it's all on camera, I think. He's never gonna get out of jail ever again. This guy's fucked.
The evidence will show that at the age of 16, he, along with an accomplice, robbed a young woman by the name of Taradia Hill at gunpoint in front of her child.
That's the other thing he did. He robbed a mother in front of her child at gunpoint. Yeah, this guy's a scumbag. Let's be honest here, boys. See, the chat's just so brain dead. Someone just said, y'all getting real desperate. Where's the evidence at? This is opening statements, buddy. Like, what are we doing here? Like, the chat shouldn't even be allowed to be on. It's just brain dead people in the chat, dude.
A rental car which these defendants had gone and gotten the windows blacked out, tinted earlier the day that Chanel Drinks was going back.
These boys rented a car and got the windows tinted. That's fucking crazy. Because why else would you do that?
Their actions and their words, the evidence will show, proves their agreement to participate in this enterprise through these illegal activities outlined and render a verdict, the only verdict that seeks the truth, and find these defendants guilty of each and every crime listed on this indictment. All
right, so now Mr. Shart right here, Shannon Stillwell's lawyer, allegedly shot Donovan Thomas and killed him. He's a known shooter. I've seen people describe him that way. It's not me.
He's been accused of the murder of Donovan Thomas in 2015. He is not guilty. I'm going to ask you to focus on a couple colors just to keep in mind as you hear the evidence. Okay, the first color is dollar bill green. Dollar bill green, as you may guess, is the exact shade of green that the U.S. government uses when printing U.S. currency. The evidence in this case will show that many of these young men grew up without dollar bill green. You'll hear that he grew up in the Forest Cove apartments, which has since been condemned, and he was raised by his paternal grandmother, Betty Jackson. He couldn't live with his mother, who had succumbed to drug addiction, tried to make it in the rap game. But you'll hear that Shannon, like many other young men chasing the same dream, weren't making any money. And bills have to be paid, kids have to eat, and rent becomes due. In this case, and we're not going to hide from it, the chase of dollar bill green turned into a different shade of green. Shannon was charged with possession of marijuana with intent to distribute approximately 1 ounce over 10 years ago. And you'll hear that he pled guilty and did his time. You'll hear that in 2015, in July of 2015, he was charged with possession of marijuana with intent and possession of a firearm. And you'll hear he pled guilty, took responsibility, did his time. You'll hear that in September 25th of 2019, he was arrested and charged with possession of a firearm. And he took responsibility and he did his time. We're not hiding from the fact that Shannon Stillwell has sold drugs. We're not hiding from the fact that he's been found in possession of marijuana. We're not hiding from the fact that he's been found in possession of a firearm. His motivation was to make money for him, to live, to pay rent, to eat.
He's trying to separate Shannon Stillwell from YSL by saying he was doing it only for himself, just to survive. In a juror's mind, it could, pull in some heartstrings and be like, oh.
Selling marijuana and then calling someone from YSL saying, hey, I got some money to support the organization. Or calling Jeffrey Williams and saying, hey, I got some money for you, man. No, that was for him. He was a drug dealer. He pled guilty. He did his time. Just like thousands of other people in Atlanta. This has nothing to do with YSL. Has nothing to do with the January 10th shooting of Donovan Thomas. It has nothing to do with the 2022 shooting of Shannon Briggs, a drug dealer selling drugs to put food on his own table. So for studio time to chase his case is a wrap. I'm going to ask you, as close of evidence, to find Shannon Stillwell not guilty. Count one. Color, besides dollar bill green, and I guess bill butt green that I like to talk about, is Fulton County blue. Now, Fulton County blue refers to the Fulton County Jail. And Fulton County blue refers to the jumpsuits that these individuals wear. The county-issued jumpsuits, typically navy blue, deep navy blue, and say Fulton County inmate on the back. You'll hear about the conditions of jail life and Fulton County jail life in particular.
They're gonna start shitting on the jail conditions because Thug did have some inhumane jail conditions. They like kept the lights on 24/7 so he couldn't sleep well and had to like cover his face to sleep. And apparently they were only giving him snacks to eat, but you know, who knows if this is true or not. But they're gonna try to blame the jail conditions for people coming.
The state's key witnesses in this case that they're going to call to testify, that I anticipate that they will call to testify against my client Shannon Stillwell, when they became involved in this case, they were all wearing the Fulton County blue. When did these men say what they have to say? Did they say it when they first got the information to share? Or when they claimed they first got the information to share? Or did they share it when they found themselves wearing the Fulton County blue?
His 2 points are kind of weak so far.
Case is shooting of Donovan Thomas was caught on surveillance video. Now, I'm not going to suggest that it's the highest quality surveillance video, but it was caught on surveillance video. And you'll be able to watch the surveillance video. Zoom down McDaniel Street towards Northside Drive, headed northwest, I believe. That an individual starts shooting out of the sunroof in the direction of Donovan Thomas and others. And you'll see that surveillance video for what it is and what it isn't. Detective Thorpe is the Atlanta Police Department detective that was assigned this case in January 2015. But you won't ever hear that these shell casings were linked to any particular gun or Shannon Stillwell or anything else. And there were no eyewitnesses on January 10, 2015 coming forward saying, yes, I was here and this is what I saw. And I saw this person do this. There was none of that. Remained unsolved. No one had been charged for 9 months and 9 days. On October 19, 2015, 9 months and 9 days after the Donovan Thomas shooting, a man named Nicholas Robinson was arrested on the streets of Atlanta and brought to Fulton County Jail for various pending charges. And you will hear evidence that Mr. Robinson decided he needed help. He didn't want to wear the Fulton County blue. You'll hear that he contacted Atlanta Police Department and got in touch with Detective Thorpe. And Detective Thorpe came out and interviewed this Nicholas Robinson. You'll hear what Nicholas Robinson said in this interview, how he gave his vantage point to Detective Thorpe. How Nicholas Robinson said that he was seated at the MARTA bus bench right across McDaniel Street from the barbershops. You'll hear that Nicholas Robinson told Detective Thorpe that he saw it all. And he saw the people that were inside the car. And he gave names. Nicholas Robinson said, I saw Antonio Sledge. He came out the sunroof shooting. I saw Kenneth Copeland. He was in the front passenger seat. And yes, I saw Shannon Stillwell, my client, in the back passenger side shooting at handle. So Detective Thorpe, after taking this information from Nicholas Robinson, who just broke the case, created photo lineups. And you'll learn what a photo lineup is. It's essentially 6 photos that contain a picture of a suspect and then 5 what we call fillers. And Detective Thorpe showed these photo lineups. A photo lineup with Antonio Sledge and then a photo lineup with Kenneth Copeland. Each person had their own photo lineup just to ensure that Nicholas Robinson could pick these people out of a photo lineup. And Nicholas Robinson did. Nicholas Robinson signed his name and said, these were the people in the car. Ladies and gentlemen, why am I telling you this? Well, Detective Thorpe had 2 small problems. You will be able to watch the surveillance video and the lighting conditions out there and the fact that there's gunfire going every which way and how fast the car is moving, and you will be able to judge ever even believable that someone could see 4 people inside a car under those conditions. But there was a bigger problem with Detective Thorpe. That during this interview with Nicholas Robinson, it wasn't only Detective Thorpe, there was another investigator there, an investigator Gaither. And while Detective Thorpe was talking to Nicholas Robinson, Detective Gaither was doing some investigation of her own and looking into Nicholas Robinson and who this guy was who had just been arrested. After Nicholas Robinson picked out all these people, including my client, Detective Gaither had to tell Detective Thorpe, that guy in there that just signed those photo lineups, that just helped our case, his name isn't really Nicholas Robinson. He lied to us about his name. His name is actually Spencer Wright.
So this case that Shannon Stillwell was seen shooting, apparently the guy that pointed him out lied about his name initially.
Yeah, I've come to learn that your name is not actually Nicholas Robinson, it's Spencer Wright. Could you look at these photo lineups again, and instead of writing a fake name Nicholas Robinson, could you actually sign your real name Spencer Wright?
That's a good point because it makes the witness look untrustworthy. Like he's doing his job here. It's what a lawyer's supposed to do.
Across from the barbershop? No one. It was all fabricated. It was all made up. It was all a lie. We've been able to review Spencer Wright's jail phone calls to associates made around that time. All but admitting, I'm lying. I need to get out of here. I'm inserting myself into a case so I can get favorable treatment. The state has since dismissed the charges against Antonio Sledge, Kenneth Copeland, and Demetrius Garlington. They continue to push forward against Shannon Stillwell.
Wait, so all 3 other people in the car, their charges were dismissed, but not Shannon Stillwell? There is a few red flags with this case. Do I think he did it? That's another question. Is this lawyer kind of cooking? Kinda.
What was Spencer Wright wearing when he fabricated his story, Fulton County Blue. You'll hear that Kenneth Copeland hates jail more than anything. The problem is, for someone that hates jail more than anything, he does a horrible job of avoiding it. And you'll hear that throughout this investigation, he's repeatedly arrested by Atlanta Police Department and other jurisdictions. And you'll hear 2 of those arrests were on June 10th of 2015 for guns, October 28th, 2021, guns, felon possession of guns. He makes it very clear about what he thinks about wearing the blue. But the interesting thing about him is, as you will hear, is every time he's arrested, law enforcement runs out to talk to him. And he goes through the same song and dance about how they'll do anything. Just don't, please don't make me wear that blue. Kenneth Copeland is no longer wearing blue. And he's not charged in this case.
This is the Kenneth Copeland guy he's talking about, who's Lil Woody, who, like, I'm pretty sure straight up snitched on video. Like, threw everyone under the bus, I'm pretty sure, so.
You'll see that there's no first car, second car. You'll see that there's no signal. You'll see that Donovan Thomas wasn't just leaving the barbershop, that he had, in fact, like the state had already stated, been hanging out with friends in that parking lot for quite some time prior to the shooting. And most importantly, you'll hear, or you'll see on the video, that Sammy Davis's claims that this car stopped are 100% wrong. The car never stops. The car drives on by. What you will not see on this video is any indication at all that this shooting occurred while my client's car was beside Mr. Drink's. You will not see any muzzle flash, you will not see any commotion, you will not see any fight, you will not see anything at all that suggests that that's when the shooting occurred.
All right, that's pretty much it. So Max Shark came up there and defended Shannon Stillwell by saying these witnesses they're going to call are just guys trying to get out of jail because they hate how inhumane the conditions are in jail, and that he was just a drug dealer making money for himself, not involved in YSL whatsoever, and no footage points to him being there. The witness that pointed them out lied about his name, so that makes the witness untrustworthy. A few decent points, some of them kind of dumb, but the last 2 were pretty good. But other than that, this trial's been a disaster on day 1. Complete chaos. I'll keep coming this trial. Love you guys. Thanks for support. Comment down below. Hit the like button. Subscribe. Peace out.